Spinal injuries can result in varying degrees of limitation in mobility or paralysis. Primary factors which help to establish the severity of the injury are the exact location of the injury as well as the intensity of the damage. Motor and sensory function can be a significant issue with this injury type. For the injured party, the question of how severe was the injury to the spinal cord will need to be addressed. Different types of spinal cord injuries consist of the following. Cervical. Cervical spinal cord injuries occur in the neck region, just below the brainstem. These injuries are often caused by traumatic events such as motor vehicle accidents or falls, and can result in paralysis of both the upper and lower limbs, as well as impaired breathing. Thoracic spinal cord injuries occur in the upper or mid-back region. These injuries typically affect the trunk and legs and often result in paraplegia, which is the loss of motor and/or sensory function in the lower limbs. Lumbosacral injuries affect the lower back and pelvic region. These injuries often impact the nerves controlling the legs, hips, bladder, bowel, and sexual function, leading to weakness or loss of control in these areas. Cauda equina syndrome. Cauda equina syndrome occurs when the nerve roots at the base of the spinal cord are compressed. This condition can cause severe lower back pain, leg weakness, and loss of bowel and bladder control, and requires urgent medical treatment. Law of negligence. Negligence occurs where one person owes a duty of care to another. Examples are one road user to another, a doctor to a patient, an employer to an employee. In Lievre v. Gould, 1893, 1 QBD 491, it was stated, "The question of liability for negligence cannot arise at all until it has been established that the man who has been negligent owed some duty to the person who seeks to make him liable for his negligence. A man is entitled to be as negligent as he pleases towards the whole world if he owes no duty to them. There must be a breach of this duty. The exact breach must have caused the damage. The harm must be foreseeable. In one case it was stated, when the danger is reasonably foreseeable, the duty to take care to avoid injury to those who are proximate, when their proximity is known, is based upon the duty that one man has to those in proximity to him to take reasonable care that they are not injured by his acts." Step 1 is to have a meeting your solicitor to discuss the facts and investigate if a case can be brought. The person will obtain a legal opinion with respect to the strengths or weaknesses of such a case. If a case is commenced, it proceeds to the Personal Injuries Assessment Board. Under Section 8 of the Civil Liability Act, 2004, this is called a letter of claim. A person pursuing an action should serve notice in writing to the other person within 1 month of the date of the accident of their intention to pursue this course of action. This is the application form to the Injuries Board. Form B is the Injuries Board's form for the doctor who is completing the report. If the case is not dealt with or concluded in the Injuries Board process, then legal proceedings, mediation, or early resolution can be explored. Court process. At the outcome of the Injuries Board process, once a decision is made, the applicant and respondent must agree to the assessment. In that case, the matter is concluded. If either side do not agree to the outcome, the Injuries Board consider the matter too complex or for another reason can issue document titled anti-authorization. In this circumstance, the application must proceed to court if they want to advance their case. If you have any questions, our contact details are 01 546121 or 052 612 1999, or our email address is info@clearysolicitors.com, personal injuries. In contentious business, a solicitor may not calculate fees or other charges as a percentage or proportion of any award or settlement,